You're listening to the Valley Current.
Imagine sitting at your kitchen table late at night. The house is completely quiet, just the hum of the refrigerator.
Right, that classic late night feeling.
Yeah, exactly. And you have a microphone plugged into your laptop, and you are recording these voice memos.
Just, talking into the void.
But not just casual thoughts. You are recording highly personal, deeply emotional memories. You're doing this to help a close friend write a book about the absolute hardest year of your life.
Oh, wow. That's heavy.
It really is. It's raw. It's vulnerable. You are literally crying into the microphone.
Yeah, putting everything out there.
Exactly. And eventually, a few weeks later, you realize some of those memos are just, well, they're too painful, too intimate.
So you want them gone.
Right. So you drag those specific audio files to the trash icon on your computer. You click empty trash and you watch them disappear. They're gone. You breathe a sigh of relief.
Or, at least you assume they're gone. Because that is the whole illusion of the digital trash can.
Oh, man, yeah. Because years later, a team of federal investigators knocks on your friend's door for a totally unrelated inquiry.
Right.
They borrow his external hard drive, they take it back to a lab, and they use these sophisticated military-grade forensic tools to essentially resurrect those deleted intimate files from the digital graveyard.
Which is terrifying, if you think about it.
It is. They listen to your most painful moments. But they ultimately decline to charge you with anything at all. Case closed. Right.
I'd certainly hope so.
Nope. Because then a totally different set of officials announces that in the name of public transparency, they are going to publish those deleted intimate memos on the internet for the entire world to download, remix, and broadcast.
It sounds like an episode of a dystopian sci-fi show. Just a total cautionary tale about the surveillance state.
It really does, but this is not a hypothetical scenario at all. This is the exact fact pattern of a massive legal collision happening right now.
Yeah, it's wild.
And that brings us to the specific focus of today's deep dive. We are looking at the May 26th, 2026 lawsuit, Biden v. U.S. Department of Justice.
No, I know. The second we say the name Biden or Department of Justice, a million preconceived notions pop up for people.
Oh, absolutely. We live in an incredibly polarized time, but I want to pause here and talk directly to you, the listener, for a second.
This is super important.
We are stepping entirely outside of the political arena today. Both of us.
We have to.
Yeah.
If we get bogged down in partisan politics, we completely miss the earthquake happening beneath the surface of this case.
Exactly. Our source material today is a remarkably detailed legal advisory newsletter. It's dated May 28th, 2026.
Right. Authored by Jack Russo.
Yes, the managing partner at Computer Law Group, LLP. And our mandate for this conversation is to break down his analysis impartially.
We are not taking political sides here, folks.
Not at all. We are not endorsing the viewpoints of any political entity, whether that's the president, special counsel Robert Hur, the DOJ, or Congress.
Right. We're just looking at the legal architecture.
Exactly. Our mission is to explore this source material to understand a profound structural test. In an era of advanced digital forensics, can anyone keep a private record private once it falls into government hands?
Because the legal strategy detailed in this advisory, it isn't just about one public figure.
Yeah, it's bigger than that.
Much bigger. It's a stress test of privacy laws that were written decades before anyone even knew what a gigabyte was.
So let's look at the actual materials at the center of this dispute. Because according to the advisory, we are talking about roughly 70 hours of audio recordings.
And 117 pages of transcripts. Right?
Yep. These stem from conversations that took place back in 2016 and 2017. The president was at his home speaking with his memoir writing partner, Mark Zwanitzer.
And the subject matter is, it's really critical to understand the legal stakes here.
Oh, well, definitely. What were they talking about?
Well, they were working on a book titled Promise Me Dad. It's a book entirely focused on the year Biden's son, Beau, was dying of brain cancer.
Wow. So we are dealing with materials that are fundamentally intensely intimate.
Exactly.
Yeah.
In fact, career attorneys at the Department of Justice previously argued in court that releasing these recordings would be tantamount to publishing an audio version of a personal diary.
An audio version of a personal diary. That phrase really sticks with you, which makes the mechanism of how the government obtained them just, so jarring.
Yeah, because they didn't just subpoena him for his diary.
Right. The special counsel's investigators obtained Zwanitzer's hard drive and ran forensic recovery on files he had intentionally deleted.
Which brings up a huge point about how we view digital files. The act of deletion used to mean something very final in the physical world.
Like if you burned a paper diary, it was ash. It's gone.
Exactly. But in the digital landscape, as the newsletter points out, hitting delete just removes the directory pathway to the file.
So the computer just forgets how to find it.
Right. The data itself remains physically on the platter of the hard drive until the computer randomly overwrites it with new data.
Oh, I see.
So these forensic tools, they just bypass the directory entirely. They read the raw data on the disk and pull those deleted files right back into existence.
Okay, let's unpack this. I think of it like taking a wrecking ball to a house. But then a forensic team comes in with tweezers, picks up every single speck of dust, and completely rebuilds the house in a lab.
That is a perfect analogy, yeah.
And now that they have rebuilt this deeply personal house, the DOJ has been ordered to release it to the public by June 15th, 2026.
Which leads to this bizarre upside-down lawsuit.
Right. Biden is suing the DOJ to stop them. The newsletter calls this a reverse FOIA lawsuit.
It is a really strange posture to be in, legally speaking.
It seems completely counterintuitive. I mean, FOIA, the Freedom of Information Act, is something we usually associate with, like journalists fighting to uncover corruption.
Or citizens demanding environmental reports, yeah.
Exactly. It's a tool used to pry information out of the government. So a reverse FOIA lawsuit feels like calling the fire department, not because your house is on fire, but to beg them not to randomly open the fire hydrants and flood your street.
I like that framing. A lot. But the immediate question a lot of legal observers have is, if FOIA is the mechanism threatening the release, why can't he just use FOIA to block it?
Right. Why create a reverse FOIA concept at all? Shouldn't FOIA have a built-in brake pedal for the person whose data is being exposed?
You would certainly think so. But the Supreme Court actually slammed the door on that idea back in 1979.
Wow, that long ago. What was the case?
It was a case called Chrysler Corp v. Brown. The court looked at the text of the Freedom of Information Act and concluded it is purely a disclosure statute.
Purely a disclosure statute.
Right. It creates a mandate for agencies to release information, subject to certain exemptions. But it does not grant any private citizen the affirmative right to sue the government to prevent a disclosure.
Wow. So FOIA is strictly a one-way street. It's an engine designed only to push information out the door.
Yep. It has zero mechanism for pulling things back in.
So if you are the person trying to stop the government from releasing your recovered deleted files, FOIA gives you nothing.
Nothing at all. You have no direct right of action under FOIA. You are forced to route your entire challenge through a completely different piece of machinery.
Which?
The Administrative Procedure Act, or the APA.
Ah, the APA. It feels like whenever a massive structural lawsuit happens against the government, the APA is always the vehicle.
Because the APA essentially functions as the operating system for the entire federal bureaucracy.
Makes sense.
If an agency does something you think is illegal or unfair, you usually sue under the APA. And in this specific complaint, the plaintiff pleads 3 distinct counts under a very specific provision, Section 706(2)(a).
Okay, walk me through that. What does that section actually demand of a judge?
Well, Section 706(2)(a) instructs a reviewing court to hold unlawful and set aside agency actions if they are found to be arbitrary and capricious.
Arbitrary and capricious.
Got it. Or an abuse of discretion, or contrary to law. So his legal team cannot just walk into court and say, hey, my privacy is being violated.
They have to use the agency's own rule book against them.
Exactly. They have to translate that personal grievance into administrative law terms. They have to argue the Department of Justice is behaving arbitrarily and contrary to existing privacy statutes by planning this release.
That is a staggering hurdle for an individual. Just, put yourself in that situation.
It's a nightmare.
Your digital exhaust, the stuff you threw in the virtual trash because it was too painful, gets swept up by a federal agency. And you find out there is no simple, straightforward privacy law you can invoke to say, hey, that's mine, don't publish it.
Right. You can't just call foul.
You literally have to hire a legal team to mount a complex administrative law challenge, accusing a federal agency of being arbitrary and capricious, just to hit the pause button.
And that pause button is what litigators call a preliminary injunction. It's under Rule 65 of the Federal Rules of Civil Procedure.
And they are racing the clock here, right?
Oh, absolutely. They have to secure that injunction before the June 15 deadline. Because once those files hit the internet, the damage is permanent. You can't put the genie back in the bottle.
This highlights a structural issue that goes way beyond one former president, though.
It really does.
The reason anyone has to rely on this convoluted APA lawsuit is that the traditional shield of privacy we used to enjoy as a society has completely vanished.
Gone entirely.
The advisory actually dedicates a whole section to this. It calls it more data, less privacy, the compression of the private sphere.
And the statistics the advisory cites to back that up are genuinely alarming.
What kind of numbers are we talking about?
Well, in fiscal year 2024, federal agencies received 1,501,432 FOIA requests.
Over 1.5 million requests in a single year? That is an industrial scale of information extraction.
It represents a massive escalation, and every single time a deleted email is recovered or a voice memo is pulled from unallocated space on a hard drive.
Or even just a text thread synced to a cloud server.
Exactly. It creates a new piece of permanent evidence. And this entirely shatters a concept the law used to rely on heavily, a concept called practical obscurity.
Practical obscurity. I'm so fascinated by this concept. It sounds like a philosopher's term, honestly.
It does, but it's actually rooted in a hard legal precedent.
Yeah.
It was officially recognized by the Supreme Court in 1989.
In which case?
A landmark case called U.S. Department of Justice v. Reporters Committee for Freedom of the Press.
Okay, so what did they say back in 1989?
Well, in that era, the court realized that even if information technically existed in various public records scattered across the country, say, a rap sheet with arrests from 5 different states.
Right. Technically public, but hard to find.
Exactly. There was a recognized privacy interest in the fact that it was incredibly difficult to assemble all those pieces.
The newsletter brings up an incredible analogy here, the old paper diary locked in an attic.
I love that analogy.
Right. If I read a diary and put it in a box in my attic, technically, someone could break into my house, climb up the ladder, dig through the dusty boxes, and read it.
It's physically possible.
It is. But the sheer physical effort, the logistics, the friction required to achieve that, well, that friction is my privacy.
That is the absolute essence of practical obscurity. Privacy wasn't just a legal right written on a piece of paper. It was a physical reality dictated by the limits of the analog world.
You had to sweat to violate someone's privacy.
Right, but consider what happens when that same paper diary is scanned into a high-resolution PDF.
Made fully text searchable with optical character recognition.
Perfectly copyable without any degradation and posted on a public server.
It's crazy, because not a single word of the diary has changed. The information is mathematically identical to what was in the attic.
But the privacy is completely obliterated because the friction is gone.
And this is where the courts have had to adapt, right? Recognizing that digital data isn't just a faster version of paper.
Right. It represents an entirely new paradigm. The advisory draws a really brilliant parallel to Fourth Amendment jurisprudence to illustrate this.
Now, Fourth Amendment cases are usually about police searches, like warrants and things.
They are, yeah. But the underlying logic applies perfectly to privacy here. Look at Riley v. California from 2014.
Oh, the cell phone case.
Exactly. The Supreme Court had to decide if police could search a cell phone without a warrant, incident to an arrest.
Because historically, police could always search a physical wallet or a pack of cigarettes found on a person.
Right, but Chief Justice Roberts wrote that a modern cell phone is fundamentally different. He noted that they hold the privacies of life.
The privacies of life. I like that.
He basically said that treating a cell phone like a physical wallet is like saying a ride on horseback is materially indistinguishable from a flight to the moon.
That is such a great line. Because a phone isn't just a thing you carry in your pocket. It's a portal to your entire existence.
Then the court pushed that logic even further in 2018 with Carpenter v. United States.
What was that one about?
That case dealt with historical cell site location information. Basically, the data showing everywhere your phone has been over months or years.
Oh, tracking data.
Right. And the court ruled that aggregated digital location data is an entirely different species of record compared to old-school physical surveillance.
Okay, so if a cell phone is a different species and location data is a different species, then these forensically recovered audio files from a private memoir session.
They are definitely not the equivalent of finding a loose piece of paper on a desk.
Not at all. Think about the modern threat vectors here. If someone found an analog cassette tape of a private conversation 20 years ago, they could, I don't know, play it for people in their living room, maybe make a grainy copy.
Yeah, the distribution was super limited.
But a pristine, forensically recovered digital audio file today, it can be run through AI transcription models in seconds.
It can be voice printed.
Exactly. The vocal cadence can be fed into deepfake models to make the person say things they never even said.
It can be infinitely clipped, stripped of context, and algorithmically amplified across social media platforms forever.
The infinite exploitability of it is terrifying. Once a human life is reduced to raw digital data, practical obscurity can't protect you anymore.
No, it's totally useless.
You are entirely dependent on whatever statutory locks exist on the door. And according to the CLG advisory, his lawyers aren't just relying on one lock here.
No, they brought 3 distinct statutory arguments to this fight.
A layered defense.
It is the most prudent strategy in administrative law. I mean, if you only give the judge one reason to rule in your favor and that reason has a flaw...
We lose everything.
Exactly. But if you provide 3 overlapping independent statutory barriers, the government has to successfully defeat every single one of them to release the files.
I picture it like a heavy oak front door with 3 deadbolts on it. The government has to pick all 3 locks perfectly to swing the door open.
Right.
But the homeowner, in this case, Biden only needs one of those deadbolts to hold strong and the door stays shut.
That's a great visual.
So let's examine these locks. What is the very first one?
The first deadbolt is FOIA Exemption 7C.
Okay, 7C, and how does that function?
This exemption specifically shields records compiled for law enforcement purposes if their release could reasonably be expected to constitute an unwarranted invasion of personal privacy.
I want to focus on the exact phrasing there. Could reasonably be expected.
Yeah, those words matter a lot.
In legal terms, that feels like a very low hurdle for the person trying to keep the information private. You don't have to prove it will ruin your life, right?
Right.
Just that it could reasonably invade your privacy.
It is arguably the most protective standard in the entire FOIA framework. And the context of how the government got these tapes really supercharges this exemption.
Because it was a criminal probe. Right.
Exactly. These recordings were seized by a special counsel running a criminal investigation. But that investigation concluded with 0 criminal charges.
That seems critical. I mean, if someone is indicted and goes to public trial, the public interest in the evidence is massive.
Sure, it becomes part of the public record.
But if the government investigates you, takes your private grief diary, and then says, never mind, no crime here, well, the privacy interest should theoretically remain paramount.
And courts heavily weigh the absence of charges. Releasing intimate materials gathered during a dry-hole criminal probe is generally viewed by judges as highly invasive.
Which makes Exemption 7C a very sturdy lock on our door.
Very sturdy. But they didn't stop there. The second lock is FOIA Exemption 6.
Okay, how does Exemption 6 differ from 7C?
Exemption 6 shields personnel and medical files and similar files whose disclosure would constitute a clearly unwarranted invasion of personal privacy.
Okay, the language just shifted. We went from could reasonably be expected to would constitute a clearly unwarranted invasion.
Right. It's a tighter standard.
That demands much more certainty from the plaintiff.
It is a higher evidentiary bar, for sure. But it serves as a critical reinforcement. You see, the government often argues that Exemption 6 doesn't apply to high-level officials.
Because they're public figures.
Yeah, the argument is that public figures inherently forfeit their privacy. However, the advisory directs us right back to that Reporters Committee case from 1989.
Oh, the practical obscurity one.
Exactly. The Supreme Court made it unequivocally clear in that case that public figures do not completely shed their personal privacy interests just by holding office.
Which, you know, makes sense. Just because you are elected to office doesn't mean the public has a right to your medical records or your private conversations about a dying family member.
Right. The office doesn't erase your humanity.
All right, so we have 2 locks based on FOIA exemptions. What is the third deadbolt?
The third lock steps outside the Freedom of Information Act entirely. It relies on the Privacy Act of 1974.
Okay, different statute.
Under 5 U.S.C. Section 552a(b), the federal government is broadly prohibited from disclosing any record contained in a system of records without the prior written consent of the individual to whom the record pertains.
That sounds incredibly definitive.
Yeah.
No disclosure without consent.
It sounds bulletproof, doesn't it?
It does. Why isn't that the only lock you need? Why even bother with the FOIA exemption?
Well, because the Privacy Act contains 12 specific statutory exceptions. Situations where the government is allowed to bypass the consent rule entirely.
There's always an exception.
Always. And one of those exceptions, Exception B9, allows an agency to disclose records to either House of Congress or to a congressional committee with jurisdiction.
Oh. And since the House Judiciary Committee is heavily involved in this specific dispute, that exception threatens to pick this third lock entirely.
It is the absolute battleground for count 3 of the complaint. His lawyers are arguing that the congressional exception does not validly apply in this specific instance.
Gotcha.
We will dive into the mechanics of why they argue that later. But that is the architecture of the defense. Exemption 7C, Exemption 6, and the Privacy Act.
Looking at this, I'm noticing a glaring omission in this legal architecture.
What's that?
We have talked about FOIA, the APA, and the Privacy Act. What about the U.S. Constitution? When regular people think about privacy, they immediately think of constitutional rights. Why isn't the Fourth Amendment, or a fundamental constitutional right to privacy, the main shield here?
It is a brilliant question, and it reveals a rather harsh reality about how courts view data privacy today. The advisory does mention a constitutional backstop, specifically referencing a 2011 Supreme Court case called NASA v. Nelson.
Okay, what happened in that one?
In that case, the court actually acknowledged a constitutional interest in avoiding disclosure of personal matters.
So the right exists. Why not lead with it?
Because the advisory describes it as a thin backstop.
The thin, why?
Because in NASA v. Nelson, the court assumed the right existed for the sake of deciding the case, but they didn't deeply define its boundaries.
Yeah.
And they ultimately ruled in favor of the government's background checks anyway.
So it didn't even help the plaintiffs.
Right. Constitutional privacy arguments regarding data held by third parties or the government are notoriously squishy and unpredictable.
Judges don't like squishy.
Exactly. A federal judge is much more comfortable ruling on the mechanical text of a statute, like the Privacy Act, than they are charting totally new constitutional territory. The statutes have to do the heavy lifting. The Constitution is just a very frail safety net below it.
Okay, so we have our front door. It is secured by 3 heavy statutory deadbolts. The real mystery of this case, and what moves us into Act 4 of our discussion, is why the government suddenly decided they needed to kick this door down.
Yes, this is where things get really intense.
Because the advisory highlights a massive pretext problem and a timeline anomaly that honestly reads like a thriller novel.
It really does. This is where the legal strategy flips from being purely defensive to aggressively offensive.
Oh, so?
The most legally potent feature of the complaint isn't merely the assertion that the recordings are private. It is a direct attack on the integrity of the government's decision-making process.
Let me set the stage for why this is so wild to me. According to the source material, for 2 years, the Department of Justice stood on the inside of the door with Biden.
They were on the same side.
Yes. They aggressively fought to keep these exact materials exempt from disclosure in previous litigation. The DOJ's own career attorneys submitted a summary judgment brief in 2024, calling the privacy interests undoubtedly enormous.
They were the ones who coined the phrase, audio version of a personal diary.
Exactly. They explicitly warned a judge back then that releasing this audio would be a severe invasion of privacy with virtually zero counterbalancing public interest.
They established a rigorous, documented, factual record asserting that these tapes were exempt from FOIA.
Right.
But then in February 2026, the DOJ executed a whiplash-inducing reversal.
Just a total 180.
Totally. They notified his counsel that they were abandoning their previous stance and intended to release the materials. And crucially, the complaint alleges they did this without any formal explanation.
Let me play devil's advocate here for a second, because I think a lot of people listening might assume this is just how government works. Administrations evolve, right? New directors come in.
Sure, leadership changes.
So an agency might look at the cultural climate and decide, you know what? Transparency is more important right now. Can an agency just change its mind and adopt a new policy?
The short answer in administrative law is absolutely not.
Really?
Yeah. Federal agencies are not dictatorships. They possess massive power. But the Supreme Court has chained that power to strict procedural requirements.
Okay, what kind of requirements?
The advisory cites a foundational 1983 case, Motor Vehicle Manufacturers Association v. State Farm.
Like the insurance company?
Yep, that's the one. This case established that when an agency takes an action, it must examine the relevant data and articulate a satisfactory explanation for its choice. A judge has to see the mathematical proof, so to speak.
It's like a middle school math test. You can't just write down the final answer at the bottom of the page. You have to show your work.
That's exactly it. And the rules get exponentially stricter when an agency changes its mind.
Oh, because they're contradicting themselves.
Right. The Supreme Court addressed this in FCC v. Fox television stations, stating that an agency reversing a prior policy must show that there are good reasons for the new policy.
Makes sense.
But the true kill shot in this brief comes from a 2016 case, Encino Motorcars v. Navarro.
Okay, what did the court say in Encino?
The court ruled that if an agency's prior position rested on explicit factual findings, or if it fostered reliance by other parties, the agency cannot just pivot. It owes a more detailed justification than what would suffice for a new policy created on a blank slate.
That makes perfect logical sense. I mean, if you have spent 2 years telling federal judges these are highly sensitive personal diaries that will cause immense harm if released, you can't just walk into court on a Tuesday and say, never mind, release them.
Oh, no, you absolutely cannot.
Not without a massive, heavily documented explanation as to why the underlying facts changed. And the complaint alleges the DOJ offered no formal explanation at all.
That unexplained reversal is a bleeding vulnerability for the DOJ. But the narrative gets infinitely worse for the government when you scrutinize the timeline of events.
Oh, this timeline. This is my favorite part of the entire advisory. It is a genuine 4-day smoking gun.
It's pretty damning.
The complaint lays out the sequence of events with brutal precision. Let me run through it. On the evening of March 19th, 2026, the DOJ reaches out to Biden's legal counsel and says, "We have received a request from Congress for these materials, and we intend to comply."
Now that seems standard, right?
Right. Until you look at the actual written request from House Judiciary Chairman Jim Jordan, the formal letter from the committee demanding the materials is physically dated March 23, 2026.
4 days later.
4 days later. I'm stuck on the physics of this. How can the Department of Justice officially notify the plaintiff on March 19th that they have received a congressional request when the authorizing document for that request wasn't dated until March 23rd?
It's chronologically impossible.
And the advisory points out that on March 23rd, the DOJ made a representation that the request had been received from House Judiciary today.
It creates a catastrophic factual anomaly in the administrative record.
Yeah.
I mean, if an agency is acting on a congressional demand days before that demand officially exists,
it strongly implies coordination.
It implies that the agency and the committee were coordinating behind the scenes. And the complaint doesn't shy away from this at all. It outright alleges that the timing and context suggest the DOJ actively solicited the request from Congress.
But wait, why would the DOJ solicit a request against itself? That sounds crazy.
To manufacture an excuse. Think about it. If the DOJ knew they were going to lose the underlying FOIA battle, or if they wanted to bypass the Privacy Act locks, triggering that congressional exception B9 gives them a convenient exit ramp.
Oh, I see.
They can throw up their hands and say, hey, we have to release it. Congress demanded it. Our hands are tied.
But if the timeline exposes that as a coordinated setup, a manufactured excuse, what is the legal consequence of that?
The advisory synthesizes this threat by pointing to a very recent, highly consequential Supreme Court case. Department of Commerce v. New York from 2019.
What was the issue in that one?
That case involved the government trying to add a citizenship question to the census. The court ultimately struck the agency action down because the stated rationale seems to have been contrived.
Contrived, wow.
Chief Justice Roberts famously wrote that judicial review of agency action cannot be an empty ritual.
Meaning, if an agency tells a judge, we are doing this for reason A, but the internal emails or the timeline clearly show they're actually doing it for reason B, the court is not obligated to play dumb.
Exactly. That concept is known as pretext. The timeline anomaly here highlights a massive chasm between the DOJ's public banner of transparency and the grimy reality of the litigation timeline.
They're saying one thing and doing another.
Right. And under the Department of Commerce precedent, that pretext invites a federal judge to strike down the agency's decision entirely. In administrative law, pretext isn't just embarrassing, it is fatal.
So let's put ourselves in the shoes of the federal judge who caught this case. You have a plaintiff with 3 statutory privacy locks. You have an agency with a glaring pretext problem and a timeline that defies the linear flow of time.
It's a lot to weigh.
How does a judge take all this chaos and distill it into a decision? How do they score this to decide if they should hit the pause button and grant the preliminary injunction before June 15?
This brings us to what the advisory frames as the Rule 65 scorecard. Because a judge does not rely on intuition here, they are bound by a rigid 4-factor test established by the Supreme Court.
From which case?
A 2008 environmental case called Winter v. Natural Resources Defense Council.
Okay, the newsletter quotes Winter as calling a preliminary injunction an extraordinary remedy never awarded as of right.
Right, so it is not a participation trophy.
You have to bleed to get it.
It is notoriously difficult to achieve. And because the defendant in this specific case is the federal government, the legal mechanics shift just slightly. Another case, Nunkin v. Holder, dictates that when the government is the opposing party, the 3rd and 4th factors of the Winter test actually merge into a single analysis.
Okay, so let's run through how the computer law group assesses each of these hurdles.
Let's do it.
Factor 1, likelihood of success on the merits. Meaning, does the judge believe he has a strong mathematical probability of winning the entire case when it finally goes to trial?
The advisory rates this factor as lean favorable for the plaintiff.
Lean favorable. Based on what?
It relies entirely on the administrative law concepts we just unpacked. The unexplained agency reversal, violating the State Farm Doctrine, combined with the incredibly strong pretext argument born from the March 19 versus March 23 anomaly.
Right.
It provides the judge with firm, falsifiable legal hooks. It's not just a debate about feelings, it's a verifiable failure of process.
Okay, factor 2, irreparable harm. If the judge denies the injunction and the files are released on June 15th, will the plaintiff suffer a catastrophic harm that cannot be remedied later with, say, a financial payout?
The advisory rates this as strong. Privacy harms are the quintessential example of irreparable injury in American jurisprudence.
It is the ultimate unringable bell. If a judge denies the injunction, those audio files hit the internet on June 15th.
And that's it.
Within 60 seconds, they are downloaded thousands of times. They are uploaded to decentralized servers. They are mirrored in foreign jurisdictions.
They're everywhere.
Right. The plaintiff could theoretically proceed with the lawsuit, win a unanimous Supreme Court victory 3 years later, and it wouldn't mean a thing. The privacy is annihilated forever.
Exactly. There is no monetary damages award that can retroactively restore practical obscurity. Once it's gone, it's truly gone.
Which brings us to the merge factors 3 and 4, the balance of equities and the public interest. The judge has to weigh the devastating harm to the plaintiff against the burden placed on the DOJ, the groups demanding the records, and the congressional committee. Is an injunction in the public interest?
The advisory views this as contested. And frankly, it's the hardest hurdle. This is where the dry legal statutes collide with raw ideology.
Yeah, this is the philosophical battleground.
You have individual statutory privacy rights facing off against the potent popular banner of transparency.
So how does the legal team counter the transparency argument? It's really hard to argue against the public knowing things.
They have to execute a complex reframing. They must argue that the true public interest does not lie in voyeuristically listening to a private grief diary.
Right.
The true public interest lies in ensuring that federal agencies act lawfully, that they strictly adhere to the Administrative Procedure Act, and that they do not engage in pretextual, coordinated maneuvers to bypass privacy laws.
That is a highly intellectual argument, but it pivots heavily on the role of the Congressional Committee. Let's go back to that Privacy Act exception we mentioned earlier.
Exception B9.
Right, the one that allows an agency to bypass consent if a Congressional Committee demands the records. Does Congress just possess a magic wand? Can a committee just subpoena whatever they want, even purely personal diaries, simply to humiliate a public figure?
That is a vital question. And the historical answer is an emphatic no. The advisory points to a lineage of Supreme Court cases that check congressional power. The most quotable one is a 1957 case, Watkins v. United States.
What did the Watkins case say?
The court drew a hard line, stating explicitly that there is no congressional power to expose for the sake of exposure.
I want to highlight that phrase. No congressional power to expose for the sake of exposure. Congress is not a tabloid magazine. They need a legitimate legislative purpose.
Exactly.
But how does a judge actually test whether a committee's purpose is legitimate, especially when it involves a president?
Well, the Supreme Court provided a modern framework for that exact scenario in 2020. With Trump v. Mazars USA.
Oh, the Mazars case.
Mazars dealt with congressional subpoenas for president's financial records. And the court established a rigorous balancing test. A reviewing court must ask, does the asserted legislative purpose truly warrant the significant step of involving the president's personal papers?
Okay.
Is the committee's request narrowly tailored? Or is it a sprawling fishing expedition? And is the evidence of their legislative purpose detailed and substantial?
The newsletter admits that applying Mazars here is an imperfect fit, mostly because Mazars dealt with subpoenas to third-party accounting firms, whereas this case deals with an agency releasing records it already holds.
That's a fair distinction.
But the underlying separation of powers logic translates perfectly.
It really does. And this is where the strongest factual defense circles back to the basic chronology of the universe.
Yes. The dates are devastating to the committee's stated purpose. The audio recordings were made in 2016 and 2017. The Congressional Committee publicly claims they need these tapes to investigate the politicization of the Biden-Garland Department of Justice, stemming from Special Counsel Hur's investigation.
Do you see the chronological mismatch there?
It is massive. Special Counsel Herr's investigation did not exist in 2016. Merrick Garland was not the Attorney General in 2016.
Not at all.
The recordings of a private memoir session made years before the target era of the investigation couldn't possibly provide relevant legislative insight into how the DOJ operates today.
By exposing that chronological impossibility, the lawyers are arguing that the committee's request is a sham. It lacks a legitimate legislative purpose and is merely exposure for the sake of exposure.
Going right back to the Watkins standard.
Exactly. If a judge agrees that the request violates the Watkins standard and fails the Mazars balancing test, then the congressional exception to the Privacy Act is invalidated.
And the third deadbolt stays locked.
Precisely.
Now, anyone who knows their American history has probably been screaming at their speakers for the last 30 minutes.
Oh, I know who you're going to bring up.
We are talking about a former president, private audio recordings, and the government's right to possess them. We have to address the ghost in the room, Richard Nixon.
The Nixon tapes are the inescapable historical anchor for any dispute involving presidential privacy. The government's litigators will absolutely invoke the landmark 1977 case, Nixon v. Administrator of General Services.
In that case, the Supreme Court flatly rejected former President Nixon's privacy and separation of powers challenges against a law that seized custody of his White House materials.
They did.
The court famously reasoned that by entering public life and assuming the presidency, an individual voluntarily surrenders a certain degree of privacy. I can already hear the DOJ quoting that line in their briefs. He voluntarily surrendered his privacy by taking the oath.
Oh, they will lean heavily on that exact quote. However, the advisory cautions against a superficial reading of the Nixon precedent.
Why is that?
Because if you read deeper into that very same opinion, the Supreme Court meticulously preserved a residual zone of privacy for the executive. They explicitly mandated a screening process to identify and return purely private papers to Nixon.
And that distinction between official acts and purely private material is the entire ballgame here.
Look at the contextual differences. Nixon was secretly recording conversations taking place inside the Oval Office.
Using government-installed equipment.
Right, while conducting the official, daily, geostrategic duties of the commander-in-chief.
And that's as official as it gets.
But these recordings were made after he had left the vice presidency. They were recorded in the privacy of his personal residence.
Not the Oval Office.
Right. And they were created specifically for a personal memoir centered on the grief of losing his son.
It is the difference between a Situation Room transcript and a diary entry.
A huge difference.
And the advisory brings in another critical piece of the puzzle here, Nixon v. Warner Communications from 1978.
That case establishes a vital nuance regarding physical custody. The court clarified that mere government possession of a recording does not automatically translate into a sweeping public right to copy and broadcast that recording.
That feels incredibly relevant. Just because Special Counsel Herr's forensic team successfully bypassed the deleted directory on Zwanitzer's hard drive and seized the files.
That mechanical act of possession does not suddenly strip the audio of its inherently private nature.
Right. It doesn't transform it into public property just because the government happens to be holding the hard drive.
The context of creation remains paramount, regardless of who currently holds the physical disk.
Wow. We have journeyed through an immense legal labyrinth today. We've covered FOIA exemptions, the procedural tripwires of the APA, the evaporation of practical obscurity, and the limits of congressional subpoenas.
A lot of ground.
It is. But I want to land the plane by shifting the focus entirely to you, the listener. Whether you are a corporate executive, a founder, a public figure, or just an everyday citizen relying on cloud storage. What is the practical so what of this deep dive?
That's a great question.
What does the Computer Law Group advisory say we must learn from this high-stakes collision?
Well, if you strip away the famous names and the political theater, this is fundamentally a case study in modern privacy architecture.
It's a warning siren.
Yes. The analog protections we historically relied upon, that wonderful friction and practical obscurity of paper, are dead. We are now entirely reliant on fragile statutory texts and the discretionary willingness of a federal judge to hit the pause button.
Jack Russo lays out 3 highly specific operational takeaways in the newsletter. Let's explore those.
The first takeaway is probably the most jarring. Delete is no longer a privacy strategy.
It really isn't.
It is merely a suggestion to your operating system. You must operate under the assumption that anything reduced to a digital format, even if subsequently deleted, is recoverable, discoverable, and potentially public.
If forensic tools can pull an audio file out of the unallocated space on a hard drive years after the fact, they can easily pull your deleted strategic memos, your vented frustrations, or your private texts.
Deletion is a myth, plain and simple.
What's the second takeaway?
The second operational takeaway deals with timing. The only effective time to build your privacy record is before the crisis begins.
You can't wait until the subpoena shows up.
No, you cannot wait until a subpoena arrives to suddenly claim a document is deeply personal. You must utilize clear access agreements, employment contracts, and explicit digital categorizations to separate purely personal material from business or official records right from the moment of creation.
It is essentially demanding a prenuptial agreement for your data.
That's a good way to put it.
The advisory notes that the White House actually attempted to use access agreements early in this process, and those early documented delineations are now crucial load-bearing pillars of their legal defense.
Exactly. And the third takeaway is targeted at litigators facing a similar reverse FOIA nightmare. When you are fighting the government, the administrative record is your only battlefield.
The paperwork.
Right. The advisory emphasizes that a glaring timeline anomaly, like the 4-day gap regarding the Jim Jordan letter or an agency's unexplained reversal, is worth 10 times more than soaring philosophical rhetoric about the sanctity of privacy.
Because under the Department of Commerce precedent, pretext is the silver bullet. If you can mathematically prove the agency's stated rationale is contrived, the judge can strike the action down.
In the cold calculus of administrative law, procedural blunders defeat philosophical arguments every single time.
It is a sobering reality, and as the advisory concludes, whatever the judge decides in the coming days, it will not be the final chapter.
Not even close.
This case will inevitably trigger appeals, potentially climbing all the way to the Supreme Court. The legal doctrine forged in the crucible of this single dispute will dictate the rules of engagement for the next decade of battles over recovered emails, synced text threads, and the digital exhaust of our lives.
It sets the baseline for every single one of us moving forward.
Which leaves a lingering, somewhat chilling thought for you to carry with you as you log off today. If the practical obscurity that shielded thousands of generations of human beings is permanently gone, and the sitting president of the United States is forced to mount a multi-count emergency federal lawsuit just to stop investigators from uploading his deleted personal grief diary to the internet, what exact legal mechanism is protecting your old hard drives right now?
That is the ultimate question of the digital age.
It's led by Jack Russo. Computer Law Group, LLP, is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.